Hello and welcome to Law and Society. So, Crew Citizens for Ethics has filed its opening brief for the Colorado disqualification case that Judge Sarah Wallace ruled on. And the brief is comprehensive and ironclad. I'm going to do a brief review of it. It's a long uh, brief. So, if you're new to my channel, please like and subscribe, and let's dive in. So, what I had talked about in my previous video about this appeal that was coming, uh, that's what Crew uses as its substantive argument, but it goes much further, which is that Article 2, the mention of office in Article 2, is uh, is just various. There's a plethora of reference of the presidency being in office under Article 2. And then Crew goes into also pointing out what other parts of the Constitution uh, the presidency is referred to as an office. And it's a comprehensive list. I have retweeted, would you say retweeted, re-X'd? I have reposted on X the article by Crew that has the opening brief. So I urge you to go read the opening brief. It's about 50 pages long, and it gives you a comprehensive history, a statutory history, sort of judicial history of the construction of, you know, the Section 3 of the 14th Amendment. And then it goes into making the substantive argument of how many times the President of the United States is referred to as an office, and starting with Article 2 of the Constitution. And then it makes a distinction, which Judge Wallace made this distinction about because the president and the vice president are higher offices than senators and representatives, not putting enunciating president and vice president before senators in Section 3 of the 14th Amendment. The framers of that amendment didn't intend for the president to be included. However, Crew makes a critical argument that that's not the order in which the 14th Amendment, Section 3 of the 14th Amendment was written. It was written by branch of government as put in the Constitution. So it went from senators, congressmen, congresspeople, then it went to electors of president, and then it went to officers, executive officers, and judicial officers. So that's Article 1, Article 2, Article 3, and then it went to the state. So that's Article 4. So Crew makes this solid argument that the whole arrangement business has little to do with how the president is the highest office, and more to do with doing it in ascending order as it is prescribed in the Constitution. Also, because senators and congressmen, members of Congress, are and electors of presidents and vice presidents are not named as officers of the executive branch or officers of the judicial branch in the Constitution. They're just named as senators or congresspeople, or the electors are just the electors for president and vice president. They aren't officers as put in the Constitution. However, executive officers and judicial officers are. And Section 3 doesn't make a distinction in judicial officers either. It says all officers, executive and judicial. So, by going by Judge Wallace's argument, that would Section 3 of the 14th Amendment would not just exclude the president and the vice president, but it would also exclude the Supreme Court justices and federal judges from any sort of, if they got into uh, conduct that rose to engagement of insurrection. So that would seem inconsistent with, equal protection under the law, due process of law, to say that uh, presidents, vice presidents, and judicial officers like Supreme Court justice, who are not explicitly mentioned in Section 3 of the 14th Amendment, are therefore just, implicitly excluded, because right after saying senators, representatives, electors of president, vice president, it says officers of the executive and judicial branches, and civil or military. So it is comprehensive, Section 3, in its encompassing of officers who are part of the executive branch and the judicial branch. And then it enunciates senators and representatives, because they are not officers under Article 2, they're just senators and representatives. And then electors of vice president, president, because they are not officers of Article 1 or Article 2, but they are a critical part of Article 2 in the electing of the president. And that's also why the president cannot be an elector in their own election. So the arguments made by Crew are rock solid, and the history provided and the arguments provided historically and in construction of the 14th Amendment and Section 3 of the 14th Amendment is a is an ironclad opening brief. And as a very nice lawyer on X pointed out, Donald Trump intends to appeal all adverse rulings by Judge Wallace, which means that, the entirety of the ruling, with the exception of the end finding where the court found, Judge Wallace found for Donald Trump. And his brief is due on the 27th of this month. So when that brief comes out, I'll do my best to read it. No promises, because reading a brief written by Donald's attorneys is just like nails on his chalkboard. So, but go on to Crew's X profile or any other profile they have on other platforms, and check out their opening brief. It has everything you'll need to understand this, where Judge Sarah Wallace went wrong. So I don't know. Donald should be writing a responsive brief to this, and and then do his other. Uh, um, I think it's going to be part of the same case that goes on appeal, and oral arguments would be heard of both things. And I assume then when Donald Trump does his opening brief, there will be a responsive brief uh, by Crew to all the matters to which Donald has appealed. And I'm sure attorneys should be doing that, because generally most of the arguments are made in the briefs, and then when you get to the oral arguments, the court is clarifying things for you. It's not so much that it's a recitation of the brief, but it's the court really going and asking you exactly what you're after. And a lot of the times, there are things that come up that are not written in the brief. So read the briefs. It's important. If you can get through Donald's brief that's coming up next week, kudos to you. And I will end it there. This is late. I came on late because I was, being lazy about reading the whole brief. So, you know, I did finally, and here's a review. So if you've just joined, do go back to the beginning, and uh, that's the review of the crew opening brief for the disqualification case that is going up to the Colorado Supreme Court. If that's all, take care. Please like and subscribe.